Hi, welcome to our channel where we share the most intriguing stories. In the quiet suburbs of Austin, Texas, Malcolm Mack Kingsley never imagined he'd be at war with his own HOA. A single father balancing work and family, his world changed when his mother suffered a stroke, leaving her in a wheelchair. But when the HOA denied his request for a simple ramp, Mack knew this was a fight worth taking. Malcolm Mack Kingsley never imagined he'd find himself at war with his own neighborhood's HOA. A single father raising two kids, Josh, 13, and Lily, 9, he already had enough on his plate. Between juggling his demanding job as a freelance graphic designer and making sure his children had everything they needed, he barely had time to worry about anything else. But when his mother, Margaret, suffered a debilitating stroke, Mack's priorities shifted overnight. Margaret had always been fiercely independent. A retired teacher, she had spent decades shaping young minds, refusing to slow down even after retirement. But the stroke left her with permanent paralysis on her right side, confining her to a wheelchair. Living alone was no longer an option. Without hesitation, Mack moved her into his modest home in Lakeview Gardens, a picturesque suburban community on the outskirts of Austin, Texas. At first, the arrangement seemed manageable. The kids were excited to have their grandmother around, and Mack was relieved to keep her close, ensuring she received proper care. However, one glaring issue became evident the moment Margaret arrived. She couldn't get into the house. The home had been built with an old-fashioned elevated front porch, accessible only by 5 steep steps. Margaret's wheelchair was too heavy to be lifted easily, and expecting her to be carried up and down multiple times a day was both unsafe and humiliating. A ramp was the obvious solution. Mack wasted no time. He researched local contractors, obtained estimates, and found a professional who specialized in accessibility modifications. After reviewing the strict HOA guidelines, he meticulously followed every step, submitting detailed plans, ensuring compliance with existing neighborhood standards, and including documentation proving that this was a medical necessity. Everything was done by the book. Then the letter arrived, a crisp, impersonal email from the Lakeview Gardens HOA, signed by Lynn Hadley, the association's president. Dear Mr. Kingsley, we regret to inform you that your request for a wheelchair ramp has been denied. Such modifications negatively impact neighborhood aesthetics and may lower surrounding property values. Please explore alternative solutions that do not alter the architectural harmony of the community. Mack read the email twice, then a third time, his stomach twisted with disbelief and anger. Alternative solutions? What did they expect? His mother to levitate? Fury bubbling beneath his skin, he grabbed his phone and dialed the HOA office. Within seconds, a syrupy sweet voice answered. Lakeview Gardens HOA, this is Lynn Hadley. Lynn, this is Malcolm Kingsley. I just received your response regarding my ramp request, and I have to say, I don't understand how you can deny it. My mother is disabled. She physically cannot enter or exit the house without a ramp. A long, exaggerated sigh came through the receiver. Mr. Kingsley, I understand that this is an unfortunate situation, but the HOA has strict rules in place to preserve the aesthetic integrity of the neighborhood. A large wooden ramp in front of your home will be an eyesore. Mack clenched his jaw. This isn't about aesthetics. It's about my mother's basic right to access her own home. The board's decision is final, Lynn said curtly. Perhaps you should consider a removable ramp instead. Mack let out a sharp breath, trying to keep his voice steady. Those are impractical for my mother's electric wheelchair. It's too heavy for a foldable ramp. And frankly, the idea of setting up a temporary structure every time she needs to leave the house is ridiculous. A beat of silence, then Lynn's tone sharpened. Maybe you should have considered that before moving her in. Mack's grip on his phone tightened. That was all he needed to hear. This wasn't about preserving the neighborhood's appearance. This was about control. This was about power, and he wasn't about to back down. Mack had dealt with difficult people before. Pushy clients, rude neighbors, even the occasional school administrator who questioned his parenting choices, but nothing compared to the iron grip of Lynn Hadley and her HOA cronies. He knew there had to be some kind of recourse, some appeal process. There was no way a homeowners association could simply deny a disabled person access to their own home. Right. Determined, he pored over the HOA's governing documents, reading every clause, every bylaw, searching for a loophole. Nothing explicitly prohibited accessibility modifications, yet the Architectural Committee had the ultimate say on any exterior alterations. Essentially, they had unchecked power, and Lynn Hadley wielded it like a dictator. The next morning, Mack submitted an appeal letter demanding a formal review of the decision. He printed copies of federal laws, including the Fair Housing Act and the Americans with Disabilities Act, highlighting the sections that made it illegal to deny reasonable accommodations for disabled individuals. 2 days later, an official-looking envelope arrived in his mailbox. Another rejection. No explanation, no legal reasoning, just another flat-out denial. Mack stormed into the HOA office that afternoon, expecting a meeting with Lynn. Instead, he was greeted by Kevin Marlowe, the HOA's vice president, a smug, graying man in a perfectly pressed polo shirt, sitting behind a mahogany desk as if he were running a Fortune 500 company. "Mr. Kingsley," Kevin said, his voice dripping with insincerity. "I understand your frustration, but we have clear community standards to uphold. A large ramp in front of your home would disrupt the architectural flow of the neighborhood. You have to understand that these rules exist for a reason." Max stared at him, incredulous. "You're seriously telling me that a medically necessary wheelchair ramp is more disruptive than, say, the giant fountain in Lynn's front yard?" Kevin's expression didn't waver. That fountain was installed within HOA guidelines. Mack leaned forward, and yet nowhere in the bylaws does it explicitly ban accessibility modifications. You're making this decision based on personal preference, not policy. Kevin sighed, as if Mack was a child who simply didn't understand the rules. "Listen, we're willing to work with you. There are alternatives, perhaps a temporary ramp you can set up and remove when needed." Mack gritted his teeth. "So I should expect my elderly, disabled mother to wait while I set up a makeshift ramp every time she wants to go outside? That's your solution?" Kevin shrugged. "The board has made its decision." Mack clenched his fists. He knew a stonewalling tactic when he saw one. They weren't going to budge. Not willingly. And as much as he wanted to punch a hole through Kevin's ridiculous mahogany desk, he knew there were better ways to win this fight. He took a slow breath and forced a tight smile. "All right," he said, standing up. "Thanks for your time." Kevin's smug smile widened as if he thought Mack was finally giving up. He had no idea what was coming. Mack walked out of the HOA office seething, his mind racing through possible next steps. He had dealt with bureaucratic nonsense before, but this wasn't just some meaningless regulation. It was a blatant violation of his mother's rights. If the HOA thought they could intimidate him into compliance, they were about to learn just how wrong they were. That night, as he sat at the kitchen table helping Lily with her social studies homework, something clicked. Her textbook was open to a chapter on civil rights movements, detailing historic cases where people had fought against unfair policies and won. Laws weren't just suggestions, they were obligations. Determined, Mack grabbed his laptop and began researching everything. Within an hour, he had pulled up the Fair Housing Act, the Americans with Disabilities Act, ADA, and state accessibility laws, all of which clearly stated that denying reasonable accommodations to a disabled person was illegal. The next morning, he made a call. Nathan Carl, an old college friend and now a highly respected disability rights attorney, answered on the second ring. "Mack, it's been a while, man. What's up?" Mack wasted no time explaining everything, the denial, the bogus reasoning, the thinly veiled discrimination. When he finished, there was a long silence on the other end of the line. Then Nathan laughed. "Oh, buddy, they picked the wrong guy to mess with." By the next day, Nathan had drafted a formal legal notice citing multiple federal and state violations. It was sharp, airtight, and left no room for argument. Denial of this reasonable accommodation constitutes a direct violation of the Fair Housing Act and the Americans with Disabilities Act. If corrective action is not taken immediately, my client will file formal complaints with the Department of Justice, HUD, and state regulatory agencies. Furthermore, legal action will be pursued against the HOA for discriminatory practices, which may result in substantial penalties. Mack grinned as he read the letter. This was the first punch in a fight he was ready to win. But he wasn't stopping there. He dug deeper into the HOA's records. Through a friend who had once served on the HOA board, Mack uncovered multiple violations committed by the very people enforcing these so-called rules. The Johnsons had built a gazebo without approval, and the HOA turned a blind eye. The Petersons had installed an above-ground pool despite regulations prohibiting it. And the real kicker, Lynn Hadley herself had built that massive fountain in her front yard without submitting a request. But the gold mine came when Mack dug into the HOA's legal status. He found a major oversight. The HOA had failed to renew its corporate registration with the state for over 2 years. Legally, that meant the HOA was no longer a functioning entity. Mack leaned back in his chair, a smirk creeping across his face. They had no idea what was coming. Mack wasn't just fighting for a ramp anymore. This had become a battle for justice. The more he uncovered, the clearer it became that the HOA wasn't just being difficult. They were operating outside the law. If they thought they could bully him into submission, they were about to learn the hard way that he wasn't backing down. The morning after Nathan's letter was delivered, Mack woke up to find a bright orange violation notice taped to his front door. Violation: non-compliant mailbox design. Correct within 72 hours or face penalties. Mack's mailbox had been there for 5 years, and no one had ever said a word about it. This was retaliation. Later that day, another notice arrived, this time for excessively long grass. Mack checked. His lawn had been mowed 2 days ago. By the end of the week, he had racked up 4 more bogus violations. Trash bins left out too long, even though they were pulled in the same day as pickup. Unapproved garden decor. A small wind chime his daughter had made. Parking violation. His car was parked perfectly in his own driveway. Unapproved exterior modification. His front door had been repainted 5 years ago. Mack wasn't intimidated. He was pissed. He took pictures of every single violation notice, compiled them into a file, and sent them straight to Nathan. Then, he took the fight to the next level. Mack created a private Facebook group called Lakeview Gardens HOA Reform, inviting his neighbors to share their own experiences. Within 2 days, over 50 residents joined, and the floodgates opened. People posted story after story of harassment, unfair fees, and selective enforcement. One family was fined for their Christmas decorations, while Lynn Hadley's house remained untouched despite having a full light display with inflatable reindeer. Another neighbor was forced to remove their basketball hoop, while 3 other homes had theirs up without issue. A retired couple was threatened with a lien on their home for putting up a small decorative fence around their garden. The neighborhood was fed up. Then the real bomb dropped. A journalist from a local news station got wind of Mack's fight after someone in the group sent her a tip. She reached out, and after hearing his story and seeing the proof, she jumped on it immediately. The next morning, Lynn Hadley and the HOA board received a call from a local reporter requesting a statement about alleged discrimination and potential legal violations. And just like that, panic set in. Mack had expected the HOA to fight back, but he hadn't expected them to lose control so quickly. The moment the local news station started making inquiries, cracks appeared in their once invincible facade. The HOA board members, including Lynn Hadley and Kevin Marlowe, had always acted with impunity, confident that homeowners would either comply or move away rather than fight. But now, with the threat of legal action and a potential media scandal, their arrogance began to unravel. 3 days after the journalists' inquiries, Mack received a formal letter from the HOA's attorney, Mr. Kingsley. The board is willing to reconsider your request for a wheelchair ramp under the condition that you withdraw your legal action. Mack laughed out loud as he read it. They were scrambling, but it was too late for negotiations. They had already crossed the line. Nathan Carl, his lawyer, wasted no time filing an official lawsuit against the HOA, citing violations of the Fair Housing Act, the Americans with Disabilities Act, and state housing laws. The Department of Justice and the local Fair Housing Council were also notified. Then came the real bombshell. As part of the lawsuit, Nathan requested a formal audit of the HOA's finances and legal status. It was a routine request, but the results were anything but ordinary. The HOA, it turned out, wasn't even legally operating. Their corporate registration had lapsed more than 2 years ago, meaning that technically, they had no legal authority to issue fines, enforce regulations, or even exist as a functioning entity. In simple terms, everything they had done in the past 2 years was illegitimate. And it got worse. When the financial records were forced into public review, it was discovered that Lynn Hadley and her board had been misusing HOA funds for personal expenses. Over $60,000 had been spent on luxury landscaping for Lynn's house alone. $15,000 was allocated to community events, but no one could recall a single neighborhood event. There were mysterious expenses listed under administrative costs that led back to spa visits, fancy dinners, and private flights. When the findings were presented in court, the judge was visibly disgusted. "This is beyond negligence," the judge remarked. "This is fraud." The ruling was swift and brutal. The HOA was ordered to reinstate Mac's ramp request immediately. The association had to cover all of Mac's legal fees. Lynn Hadley and the entire board were personally fined for financial misconduct. All fines issued in the past 2 years were invalidated, forcing the HOA to repay thousands of dollars to homeowners. For the first time since this fight began, Mac let out a breath of relief. He had won. And it wasn't just a victory for his mother, it was a victory for the entire neighborhood. With the court ruling against them, the HOA board had no choice but to comply. The pettiness, the intimidation, the bogus violations, all of it crumbled under the weight of real legal consequences. But Mac wasn't done yet. Winning the battle was one thing. Ensuring this never happened again was another. The news spread like wildfire across the neighborhood. Homeowners who had once been too afraid to speak up now saw that the HOA wasn't invincible. More residents came forward with stories of unfair treatment, outrageous fines, and selective enforcement. Then came the final nail in the coffin, a petition to remove the entire HOA board. Mac didn't even have to organize it. His neighbors did. The Facebook group, which had started as a small resistance movement, had now ballooned into a full-scale community uprising. People knocked on doors, gathered signatures, and within a week, over 80% of the homeowners had signed. Far more than the required number to force a special election. Lynn Hadley tried to fight back. She sent desperate emails claiming the neighborhood would fall into chaos without her leadership. She even tried spreading rumors that Mac was trying to overthrow the HOA for his own personal gain. It didn't work. The special election was scheduled, and when the day arrived, it was unlike anything the neighborhood had seen before. People who had never bothered attending HOA meetings before showed up in record numbers. When the votes were tallied, the result was a landslide. Lynn Hadley and every corrupt board member were officially removed. In their place, the neighborhood elected an entirely new board, led by people who actually cared about the community. Dave Richardson, a retired Navy officer and longtime resident, became the new HOA president. Maria Rodriguez, who had nearly lost her home due to bogus fines, was elected vice president. A group of honest, fair-minded homeowners filled the remaining positions, promising transparency, fairness, and accountability. Their first order of business? Overhauling the HOA's policies, including a new accessibility clause that guaranteed residents the right to make reasonable modifications for medical needs, now officially named the Kingsley Provision in honor of Mac's fight. Reimbursing residents who had been unfairly fined over the past 2 years. Hiring an independent financial auditor to ensure nothing like this ever happened again. And perhaps the best part? The new leadership slashed unnecessary HOA fees, eliminating the frivolous beautification projects that had been funneling money into Lynn Hadley's pockets. Mac didn't just get a ramp for his mother, he helped change an entire community. With the corrupt HOA board officially dismantled and the new leadership in place, the atmosphere in Lakeview Gardens began to shift. For the first time in years, people felt free. The paranoia of receiving an arbitrary violation notice for something as minor as a misplaced flower pot or a child's basketball hoop faded. Mac installed the wheelchair ramp without delay. The contractors, working with full HOA approval, built it with sturdy, high-quality materials that matched the house's exterior. It was seamless, elegant, and, most importantly, functional. When the work was completed, Mac stood by as his mother rolled up the ramp for the first time, her hands gripping the wheels with determination. For the first time since her stroke, she entered the house completely on her own. No assistance, no struggle. Margaret turned to him, her eyes misty but filled with pride. "You fought for this, Mac. You fought for all of us." The HOA reform movement he had inadvertently started took on a life of its own. The new board embraced transparency, creating a community website where residents could see HOA finances, vote on decisions, and submit feedback without fear of retaliation. And the best irony of all, property values didn't drop, they went up. It turned out that having a well-run, inclusive, and legally compliant HOA actually made the neighborhood more desirable. Families who had been considering moving out decided to stay, and new buyers were eager to move in, knowing they wouldn't have to deal with an oppressive, power-hungry board. As for Lynn Hadley, she put her house up for sale within a month, but karma had the last laugh. Her listing sat on the market for 6 months because she had priced it way above its value. Eventually, she was forced to sell at a significant loss. And in the most poetic twist of fate, the family who bought it had a child with a disability. The very modifications Lynn fought against, access ramps, wheelchair-friendly sidewalks, were exactly what made the house attractive to them. Mac's fight didn't go unnoticed. He was approached by a local disability rights organization who wanted to feature his case as an example of successful advocacy. Nathan, his lawyer, was invited to speak at several property law conferences, using this case as a cautionary tale for HOAs across the state. Even his kids learned something powerful. Josh used the experience for a school project on civil rights and housing discrimination, earning first place at his district's history fair. Lily, inspired by her grandmother's resilience, started a fundraiser to help elderly and disabled residents in their community get home modifications. And Mac, he found himself in a new role, a resource for other homeowners fighting back against HOA corruption. He had helped 3 other families in nearby neighborhoods challenge unfair practices. His story had shown people that HOAs were not untouchable and that standing up against injustice could lead to real change. One evening, as he sat on the porch watching his mother chat with neighbors, something she hadn't been able to do in months, Mac allowed himself a rare moment of satisfaction. The ramp that started it all was no longer just a piece of wood and steel. It was a symbol of perseverance, community, and the power of standing up for what's right. As the sun set over Lakeview Gardens, Mac smiled, knowing that he had done more than win a fight. He had helped make his neighborhood a better place for everyone who came after him.